for your presentation. We will move on to our third speaker now, which is Paola Aurucci. Paola studied at the University of Insubria, and she finished her PhD on the Israeli Civil Code, Law and Language for a Code in a Mixed Jurisdiction. You have the floor.
Thank you. Thank you, everybody. I don't have any voice, but it's a medical condition. I didn't have a lot of parties yesterday, I promise, even if I love Tel Aviv. And so we start my presentation with a metaphor, because I'm a comparative lawyer, and we used to do that. So the plot of the novel written by the English author Mary Shelley of Victor Frankenstein, the eccentric scientist to create a grotesque creature in an unorthodox scientific experiment is well known. The extremely talented medical student wanted to bring back to life what was once dead, and developed a secret technique to reanimate dead tissue in his university, and ingeniously dug up and stitched together the best part of different dead body and brought to life his creature. Ignoring what would be the only concern for a doctor, the preservation of life. While he failed in his attempt to play God, and the outcome was an immoral creature that destroyed everything he loved, his work from an academic point of view is full of is a lot of scientific value. So, there is a sort of similarity with the Israeli Civil Code, in my opinion, because this challenge to God, this extremely scientific value of this book that was made limb by limb, with the statute of law here and high court ruling there, the unification under a unique body of 23 different statutes, the new civil legislation that relied upon an extremely interesting comparative law experiment, relying on law of different states in order to find the best solution for all the problems before, that this book that will be the conceptual framework for the development of the Israeli civil law, private law, is also a point of reference for the development of the judicial and legislative scenario. This statute was also an extremely big effort of one person, that was Aaron Barak, and this process of unifying all these statutes in this body, actually, this creature is dying on the table. And why is dying? He's dying because of different reasons, and but at the same time, I think that even if he's actually now dead, because Israel doesn't have any civil code, and was not presented for the first reason in the Knesset, so it's actually dying. It has a lot of scientific value in itself, because he's a pioneer in the legislative harmonization of common law and civil law, and rules, and is a laboratory for current attempt to unify and harmonize legal system in the global level. And is also a laboratory for the attempts to harmonize legal system in Europe. So, to better understand what's going on with this code, we have to give a look to the history of this code and of the private Israeli law. So, it's commonly accepted today that Israel is a mixed jurisdiction. It has been shaped by influence from the English and U.S. common law and from the civil tradition prevailing in Europe. but is an atypical mixed jurisdiction in many ways. First of all, because the general pattern that is a common law system that gradually take over a civil law system is not in Israel. Is not this what happened in Israel. While the first common law system replaced only local public law, including the court system and the rule of procedure, the private civil law was untouched, was left untouched. But because the story is interesting to understand the story of the geographical area where the state of Israel is right now. The law enforced in the geographical area in which Israel is located was already mixed when the state was established in 1948. And until that time, it was mixed in not a typical mixed jurisdiction. It was a mixed jurisdiction following the general rules. Since in 1516, when this area became part of the Ottoman Empire, and it was a part of the Ottoman Empire for 400 years, it was subject to Ottoman law that was based on Muslim law and European civic code, mainly French. And in the area of marriage and divorce, there was the millet system. And so the community, the Muslim, the Christian, and the Jew enjoyed the autonomous jurisdiction that included separate tribunal, each applying its own religion. In 1970, Britain conquered the entire area of Ottoman Palestinian, and from 1922, ruled it under the League of National Mandate. During that period, the legal system underwent a gradual yet profound process of Anglicization brought by the British. And the equity was important to fill the lacune. And so it was created a mixed legal system that was predominantly based on common law. But then something strange happened again in the history, because what happened is that with the foundation of the state, there was all the Jews from the diaspora that came in this area. That actually they came from Europe, so they came from Germany, Italy, France. And so they were not really into the common law system, and they brought exactly what they knew, so the civil law. And what it happened was that in 1948, there was the possibility of creating to create an entirely new system for the new established state. And the Israeli founding father just leave the situation like it was before, because they didn't have the time to create an entire new civil law. And so the real revolution started in 1960s, when they wanted to create a public law and a civil law that was Israeli, and to create the private Israeli law. They decided to do a comparative law research, just taking inspiration from the laws of all the different places where they came from in Europe. And so actually they brought the civil law from Europe. So in the field of private law, what was predominantly a common law system, there was an introduction by the legislation of the civil law, of the law of Europe, and especially of the law of Germany. And this is very strange. And what happened, there was also like this introduction like that was called the new civil legislation. So 23 laws that substitute the Magelle, that was the Ottoman system, and they were inspired by laws from different places in Europe. They were just the first phase of a second one that was to put all these laws into a code. So these laws were thought that part of, even if they were enacted by installment, because there was no time to create an entire civic code at the beginning of the State of Israel, because there were other problems, like the immigration, like the war, they did a civil code by installment. So they passed in a long period of time 23 different statutes. But this was thought as the first phase of a second one, when all these laws had to be put in one single civil code. So this fixation for a civil code, this was also because at the beginning of the State of Israel, a civil code was felt by these jurists, with this group of jurists that were called the Founding Fathers, as a symbol of modernization, as a symbol of independence of the state. And so there was also a spatial separation between the legal culture that was basically based on English common law and the political culture that was based on the continental Europe. So we have also to understand the spatial separation between culture, political culture, and legal culture that was at the beginning of the State of Israel in 1948. Also because the state was a result of this particular mixed jurisdiction that there was in the State of Israel at the beginning of the state. It was a result of a specific history of the post-colonial society, whose inhabitants are mostly immigrants from many places in the world, excluding the colonial power that was Great Britain. So those inhabitants immigrated from places other than Great Britain, and so there was this separation between the culture that was inspired by political and social legal idea of the continental Europe and the legal culture that was based on predominantly on common law. So in this context, the civil code was felt as a symbol of modernization. In 1970s, there was the other phase. So there was the putting all together all these 23 laws that was enacted in that period of time in a unique code. And there was a big effort of Aaron Barak, that was also the Supreme Court president of the Supreme Court in 2006, and a group of jurists that did an extremely interesting, from a scientific point of view, comparative law research in order to create this code and to put all together all these laws that were enacted before. But the aim of this, at the beginning, the aim of this code was just to not introduce a lot of changing, just to fix some, because at the beginning all these laws were thought as part of a code, so it was enacted that they were part of a code. But they were enacted in a long period of time, so there were the problem of terminology, and also they have to put in the code the decision of the courts, so the principle that were accepted by the courts. So all this work was done, and so the code is actually alive, but there are some political problems to become alive. The political problem is that they are connected to the person of Aaron Barak, that was the symbol of the judicial activism. So there is a political problem because they think that these codes will bring a lot of judicial discretion, a lot of power against the Kurds. And also there is a problem because there were some changes that were introduced in this code by the committee of the codification, and all this changing they have to discuss about that. So they didn't maintain the promise. Now we just want to put all the laws that we have right now all together in a code. They actually introduced some changing in the code. And so this is one of the other reasons why the code is not alive right now. And finally, I have another one, but I don't remember. Also the mentality of an Israeli lawyer that is not to find the solution in the index of the code for a single problem, but they think in a common law way. They look for the precedents, and this because Israel is actually predominantly a common law country. So we don't know what will happen to this Frankenstein.